Okay, everybody, a very happy Friday to you all. We're going to go ahead and jump right in with the third section of Chapter 13, wrapping up our Supreme Court chunk. We're going to kind of fly through this information, so if you guys have any questions at the end, let me know. We're going to kind of go quickly through it. So today we're going to talk about how justices decide cases, precedent and stare decisis, internal court dynamics, law and politics, outside influence, and the courts' power and limits. Last class, we focused all about who gets on the bench and how cases reach the court. Today is about what happens after the court takes a case. The central question here is, how do justices actually decide? The court does not decide cases by politics alone, although they have increasingly played a big role in that. And it does not decide them by law alone either. What matters is how law, precedent, institutional role, and judicial judgment come together. So, our first chunk, how justices decide cases, precedent, and stare decisis come. We talked a little bit about this Monday, but let's go a little bit more into this. Justices do not start from scratch in every case. They're going to build off of what has already been decided earlier on. So precedent matters. What does precedent mean? That means that we're going to try and decide things in a logically consistent manner every time the same fact pattern presents itself. So, for example, Monday we used the example, if my kids come in and I've said they can't have candy, I'm not going to, in one circumstance, say, all right, that's fine, give me the candy, and in the next circumstance, smack them, right? Those would be logically inconsistent outcomes given the same fact pattern. Stare decisis means respecting prior decisions. This is going to be between different cases. We talked about how res judicata is within the same case. One second, I lost my place in the notes. Here, outline. Sorry, guys. So with stare decisis, essentially what that means is that two separate occurrences happen. You have plaintiff A who comes in, and plaintiff A says, this guy stole my cow, what should the outcome be? Then, several years later, plaintiff B comes in. So those are that outcome should be the same. But res judicata means we're just dealing with the same people, the same facts. Stare decisis is not absolute. The whole concept is that it has to change. The court can overturn precedents that they have set when it thinks there are sufficiently strong reasons to do so. And so I want to be kind of clear about this here. You can have a couple of different outcomes. They can follow the original precedent, meaning they're going to do the same thing. They can they can make a distinction. Maybe if we use my kids taking candy example, the first time I take the candy away, the second time I put them in timeout, because that's different fact patterns. Now they've done it a second time after I told them not to, and that makes me angrier, right? That's distinguishing the facts. The third thing is I could say, smacking children really isn't appropriate, so even for a third, fourth, fifth offense, I'm not going to do that anymore. We're going to change the way we handle this particular fact pattern. That would be overruling myself. The important thing to remember is that only the court setting the precedent can technically overrule itself. So, can the Supreme Court overrule itself? Absolutely. Can the Court of Appeals overrule itself? Sometimes, when they are the ones who set the precedent and there's not a higher level precedent. Can a district court? same thing. If there's not a circuit court opinion or a Supreme Court opinion, then yes. All right. Students should understand that precedent matters because it promotes stability and consistency, but it does not mechanically determine outcomes. One second, I'm going to have to say something on the call I'm on in 1 second. Present. All right, good. Sorry, I had to double check to make sure I was back on mute. So let's hop on to the next check. The main takeaway here is that precedent matters because it promotes stability and consistency, but it does not mechanically determine outcomes. It pushes the court towards continuity, but it does not eliminate judicial choice. All right, so let's talk about the internal dynamics of Supreme Court decisions. We already talked a little bit about this, but once the court takes a case, the internal process matters. We're going to have oral arguments that help frame the issues. Then the justices meet in a private conference. They vote in order of seniority, with the Chief Justice voting first. If the Chief Justice is in the majority, he assigns the majority opinion. If not, the most senior justice in the majority assigns it. Justices may write a majority opinion, a concurring opinion, or a dissenting opinion. We talked a little bit about that last time. A majority opinion means that everybody agrees, or that this is the winning opinion. A concurring opinion is somebody who agrees with the outcome, but for a different reason. And they want to kind of highlight that, yeah, I agree in the outcome, but I want you to understand that I'm thinking about it differently. Whereas a dissenting opinion is, I do not agree. The court reached the wrong conclusion. Here's why. The final outcome is shaped not just by each justice's view, but by coalition building inside the court. A Supreme Court decision is not just a vote, it is also a writing and bargaining process. All right, so how do politics intersect with the law here? This is the conceptual heart of our lesson today. So justices are influenced by legal materials like text and precedent, but we also need to talk about how justices come in with their own political views, and these can affect decisions significantly. More neutral forces still matter, including precedent and deference to the elected branches, but you should learn that there's a difference between activism and judicial restraint. Restraint is where the court is going to defer more to elected branches. They're going to try and avoid making decisions if they can, whereas activism is where there's more willingness to overturn elected branch action through judicial review. That's how the textbook defines it. I think it's a little bit different than that. And the reason I think it's a little bit different than that is judicial restraint, I think, typically tries to follow the traditional rule of law or the traditional precedent that has been established, whereas activism is trying to push that envelope to advance particular political goals. So for example, the Dowd decision about abortion, probably judicial activism. We have a long body of law that has been established for a very long time. This wasn't really going against any of the other branches of government. It was the court kind of going in its own direction here. So the smartest way to teach, or to think of how this is working is There's always going to be this law versus politics component, but law, precedent, ideology, and institutional role all matter at the same time. All right, what are the outside influences on the court? How do interest groups and public opinion matter? Interest groups do not lobby justices the way they lobby Congress. Instead, we can talk about amicus briefs. That's what the chapter kind of emphasizes. An amicus curiae brief means friend of the court. For those of you who are into Latin, amicus briefs are going to be the main way that interest groups influence how the court makes their opinion. This is where somebody who doesn't have standing in the case, they're not actually a party to it, actually sit down and write a legal opinion or write a legal brief, and they get to turn it in. They don't typically get to be heard at oral arguments. I think it's possible, but they get to give their opinion to the court, and the court may or may not consider it. Public opinion is not really direct, but it still matters a little bit. The court can reflect public opinion through appointments by elected officials, sensitivity to the broader political environment, and concern about restraint to unpopular decisions. The key takeaway here is that the court is insulated from direct electoral pressure, but not isolated from politics altogether. Justices do not run for office, but they do not decide cases in a political vacuum. A note here, once I got in a fight with the Missouri Supreme Court judge, and the reason for it was because we kind of disagreed about something that the Supreme Court wanted to happen, but as an attorney practicing in the field, we couldn't actually implement. And so specifically, the court had a rule that allowed for the limited entry of appearance to talk about bond with a court. And it has a reason so that, people who are indigent can try and get out of jail quickly. There's problems with this, though. As an attorney actually doing this, even if I write the best stuff in the world, clients might not understand that I don't represent them once that bond hearing is done. And one of the judges, who I love, she's absolutely fantastic, and she's no longer on the bench, was listening to a CLE I presented and asked, should we do this? And I said, no, we shouldn't do this. And she said, but we, meaning the Supreme Court, have a rule to allow this to happen. I'm like, yeah, but practically, how do I implement that without stepping on a landmine? And I'm like, you can do it, the rule exists. But it makes it more difficult when it's actually implemented. And this kind of highlights that distinction. The Supreme Court justices mean well, and they have that kind of connection to the people a little bit, but they're also not in the field. They're not being directly lobbied. And so sometimes there's that disconnect. All right, so the court's power has some limits, and I just want to cover these really quick. And I think we got one more section after this. We're just kind of flying through it, as I said we would. So the court lacks the purse and the sword. We talked about this a little bit ago. They can't control funding. They can't, by force, implement their decisions. They rely on the other two branches to execute or implement what they have said. It often depends on Congress and the president for implementation. And then presidents in Congress can resist, delay, criticize, or try to narrow the effect of decisions. We see that happening right now. But the last time I think we really saw significant problems with the way the Supreme Court their decisions were implemented was Andrew Jackson, something like 200 years ago. So, there's that. The court also sometimes exercises self-restraint. They might say that this is the outcome, but we're not going to actually do it. Or, hey, we're just going to defer, not even take up this issue right now. Next, One major form of self-restraint is the political question idea. Some disputes are treated as belonging to elected branches rather than courts. The court is powerful because it interprets the Constitution, but it is not all-powerful because implementation and compliance are political as well as legal. All right, let's see. We are going to skip this structured activity. And again, I know this has been really quick, but I'm stuck on a call too. So the closing takeaway is that the best way to understand the court is to stop asking whether it is purely legal or purely political. It is legal. It's a legal institution operating inside a political system. Judicial review gives the court power, selection, and access shape who uses that power. Decision-making and implementation show the limits of their power. And let me make sure I've covered everything. That's it. What questions do you guys have? All right, hearing none, let me hop into Canvas. And as this is loading, I'll get to you one second. Let me hit this point. I got locked out of everything because the university decided I didn't work here anymore about 2 weeks ago. And so you guys might be wondering where your assignment is and stuff like that. I am back in. Basically, human relations left a wrong date in my file, and so IT deleted my accounts, so I couldn't get into Canvas. It has been fixed, and so we will get back to that shortly. All right, let me stop this, and then we'll go to